Yes, just before that, Advocate Johnson, we are able to sit late, so we should be able to finish today, I hope. Thank you. Yes, Mr.
Thank you, Chair.
Chair, could I ask that you excuse me at 5:15? I may rejoin you later. I have an engagement that is set down for 5:30. I thought we'd finish around about 4:30. If you're not finished when I'm done, I'll come back.
Let's see how things go. Thank you.
I'm not
Mr.
about to abandon my ship.
Thank you. Thank you.
Thank you, Chair. Advocate Johnson, before we continue, just matters for housekeeping. Chair, you gave us an assignment. On my end, I was still trying to retrieve these articles that the Chair had asked for. If you could give us perhaps another 15 minutes to half an hour, we should have a report back for you on that.
Thank you.
Thank you, Chair.
Thank you.
But otherwise, Advocate Johnson, you recall when we broke for tea, Commissioner Baloyi had specifically requested documents or information pertaining to the former Minister Pktt's siphoning, I think, of the secret fund. And you were going to make a call, if I recall, to somebody in the office. Perhaps Commissioner Baloyi can restate the request, and then you can tell us where you landed with that. That was before tea. When we came back, I clean forgot to inquire how far your efforts have gone.
You do remember what it was?
I do remember.
Yes.
And what I did together with Advocate Maga from the NPA, we did call Mr. Sissoko, and because it's not within his direct purview, we gave him the question, told him what it is the commission is looking for, and I told him who in the team might have it, and he undertook to engage them, find it if he can, and he will then liaise directly with Mr. Maga. But we had that conversation at lunch.
All right, so it's still outstanding?
It's still outstanding.
All right, thank you.
Thank you, Advocate. And I think before we part company today, we would appreciate a clear indication, perhaps through your legal representatives, on how best to deal with outstanding documents.
Yes.
That are within IDEC in light of the fact that you are now retired. You'll be able to guide us in that regard?
Yes,
Okay.
and I will also be available when council wants to message me just to hear, I'm looking for this, direct me wherever. I'll be happy to do that.
Thank you. Commissioners, I'm ready to move off that section 28 summons. As I understand section 28, all summonses are assigned by yourself. And I think that has been at least my experience insofar as the dockets are concerned. The dockets before us.
Yes, in most matters, but in other matters, and it all depends on availability, deputy directors of public prosecutions can also sign the summons.
So is that delegated authority or is that an original authority they have?
They have a delegated authority because it is incidental to prosecutions and investigations.
So would there be a written delegation of authority from you?
They all have a delegated authority, yes.
I'm interested
Yes.
in whether it's a written delegation of authority
Yes.
that we can ask for.
Correct.
So is it a general authority that you issued to all or specific persons? And if so, when is it renewable on a periodic basis? How does it work?
It's, in terms of section 20 of the NPA Act, we delegate authority, and it's a once-off delegation, unless the rank changes and you have to upgrade that authority, and of course when new persons come into the fold. And the authority for different functions delegated to the different functionaries. But the main gist of all those authorities is the ability to institute prosecutions for and on behalf of the state and to conduct investigations incidental to those prosecutions.
I ask because I'm looking at section 28(6), which I understood that most of these summonses that we've considered are issued in terms of. There are section 28 summonses.
Correct.
So where's mine? Have you located your copy?
I have a copy.
I read section 28 sub 6, and it states that for the purposes of an investigation, remember we are in section 28,
Yes.
sub A, the investigating director may summon any person or ask for any document or book in their possession or under their control, and at B, the investigating director or person designated by him or her may question any person. Do you see that?
Yes.
So most of the section 28 summonses I've seen, at least in the dockets, are signed by you, just like the one we were considering just before lunch. Now, section 28 sub 7 provides that a summons referred to in subsection 6, which is the one we've just looked at, shall be, and it states AB, and I'm interested in C, be signed by the ID or a person authorized by him or her. So there seems to be a requirement, if it's not signed by you, for specific authorization by you, which of course implicit in that is that you delegated the power. And as we know, with the rules of delegation, it must be in writing.
Correct.
So it would be fair to expect that if we come across a summons that is signed by anyone but the ID, there would be within IDEX records that delegation to be compliant with sub 7.
That is correct.
There would be a written delegation.
Yes, and that delegation, if I may, Council, is in terms of section 20 of the NPA Act, power to institute and conduct criminal proceedings. The power is contemplated in section 1792 and all other relevant sections of the Constitution to A, institute and conduct criminal proceedings on behalf of the state. B, carry out any necessary functions incidental to instituting and conducting such criminal proceedings. And C, discontinue criminal proceedings. So they have a section 20 authority, and that allows them then to deal with functions incidental to investigations and prosecutions.
I read 20 to speak to the institution and conduct of criminal proceedings.
On behalf of the state?
Yes.
Yes.
And not investigations. You recall, as I understand, IDEC has got both powers.
Yes.
Power of investigation and power of prosecution.
Yes.
And section 20, on my reading, relates to criminal proceedings, which is the prosecutorial part of the NPA. Section 28 that we have dealt with, you remember we dealt with section 28(1) and 28(13), which speak to investigations. And that particular section, insofar as investigations are concerned, and the issuing of summonses prescribes that a summons must be signed in 7 sub C, must be signed by the ID or a person authorized by him or her.
Correct.
My interpretation is that that's a separate now authorization.
Yes.
So my question was, is it fair to assume where there is a summons signed by anyone but yourselves, that there would be a record of the delegation of that power to that specific person within IDEC?
That should be, yes.
That's a fair assumption. Please turn to, we're still with file 9. I'm at 3527. This is CJC 397. Page 35, no, did I say 97? 3527, okay, thank you. I thought I'd mentioned the wrong page. 3527, that's CJC 397. And you see at the top of that document, it says it's a summons in terms of section 28.6, read with 28.7 of the NPA Act, which are the subsections we just had regard to now. You confirm that?
I confirm.
I see this is a summons issued on the 11th of May 2026. It's signed by Advocate S. Manilal. And if we go to page 3530, you have a main heading, introduction, under A, B, background. And it's at 5, it says, the information required from you relates to the conducting of an investigation into serious fraud and corruption committed within the South African Police Service. This investigation was authorized by the investigating director in terms of section 28 sub 1 sub A of the NPA Act into allegations of the commission of the following offenses. A, fraud, B, corruption. Which investigation is this? Perhaps let's move on to Annexure B, it might shed light. Annexure B provides the particulars pertaining to this investigation and states that the Pktt team that traveled to the Western Cape for the arrest of Mr. Fadiel Adams. And in that regard, IDEC requires certified copies of all travel documents for the Pktt members who traveled to the Western Cape and were involved in the arrest of Mr. Fadiel Adams for the period 30th April to the 8th of May 2026. Travel documents must include all applications, itineraries, SAP 501s, approvals. The members would have departed on 30th April 2026 and returned on the 8th of May 2026. And it's signed by Advocate Manilal. Which investigation is this? Where IDEC issues a section 28 to demanding details and documents pertaining to the Pktt team's travel to the Western Cape to arrest Mr. Fadiel Adams.
Maybe to point out at that 3527, at the foot of the page, that the investigator is Brian Padayachi.
This is somewhat confusing because it looks like IDEC is asking the police to indicate who went to, I would assume it's on the arrest of Mr. Adams, who went to arrest him and what it costs. And that isn't part of anything that I'm aware of we are doing at IDEC. This isn't brought to me. This is signed by the deputy. they are delegated to sign. But I cannot see the relevance of why we would ask who traveled. A different conversation, Chair, might have been if one wrote to the National Commissioner indicating this is a witness, we would like to know what charges he faces, something like that, a very generalized, because we want them to know he's our witness, they have taken him. But other than that, I can't legitimate this because I don't know why this happened.
Even that, why would IDEC put forward such an inquiry? Because it suggests that if the individual is your witness in some or other matter, he's then above the law and cannot be acted upon by any arm of the law enforcement. So what would be the basis for the inquiry? Unless it is interfering with that person in their capacity as a witness, which you would have to spell out in that communication.
The communication would merely be to indicate this person is a witness in our matters and we are informing you. And then that stays where it is. It becomes important when you have a witness who is subsequently arrested. You do inform the other team. We've done that in other matters as well. If you take, and not to go into his details because he has yet to come to the commission, when Mr. Matlala was arrested in Joburg on other matters, we were already busy with a corruption matter. We informed that prosecution team, colleague to colleague. I just would like you to know, IDEC is only vested with this matter into Mr. Matlala, and we're not aware of what you are doing, but if you need anything, ours is purely a corruption matter, and vice versa. That way, either teams get to collaborate, we don't trample on one another's toes, but it's a collegiality we've always afforded one another.
If you don't know anything about this, it then suggests that there are investigations that are being conducted by an organization that you don't know about. Is that how it operates? Is that how IDEC operates? That the head may not know that there are investigations against certain people and in certain matters that are happening?
Not in that sense, but if they are already busy with an investigation, and within that investigation team, they see fit to seek information that they think may help their matter, they are allowed to go ahead as investigators and prosecutors. And so I don't know why it happened.
And that would be part of an investigation. It flows from an investigation, right?
Correct.
But you are not aware that there is an investigation into the arrest of Mr. Adams.
No,
you're not aware that there's such an investigation.
No, I did see on television that Mr. Adams was being arrested. That is a matter that must get dealt with wherever it gets dealt with. So for us to want to know anything, I think it's not just about the anything. It was the detail of what was being sought.
Yes.
And what would you do with this detail if
Why
they
do you
gave
want the
detail?
names of people,
Correct.
indeed, who arrested him?
Correct.
And you say you were never made aware that there is such an inquiry or there is such an investigation that IDEC is looking into.
Correct.
Thank you.
So, and no idea why a team would have then deliberated on something like this.
Yes.
And not brought it to the attention of the head if it was going to make a difference to cases we had where he is a witness.
Yes.
That's different. But even when you look at the level of the detail that is asked, it can in no way further the investigation that we have.
Thank you. Thank you, Mr.
Thank you, Commissioner Baloy. Based on your response, doesn't reading this Section 28 summons and the detail contained therein as regards what IDEC wants, have we not crossed the line of interference? Is this not interfering with the affairs of SAPS as law enforcement agencies in circumstances where IDEC doesn't know, at least from these summons, why that particular individual was arrested? is this not rendering subs accountable to IDEC for decisions that subs takes? And if so, what would be the statutory entitlement to that?
It does not make sense at all. And that's why I said that there's no requirement, there's no legal requirement. They may have used a legal document to procure this or attempt to procure this, but there's no legal basis for the existing investigations in IDEC where Mr. Adams made a 27 referral and however many supplementary A1s. It cannot take the matter further knowing who arrested him, why they arrested him, and so on.
So would it be fair then, based on the face of this document and your responses, I take it you have no knowledge of the summons, you never authorized the issue of such a summons?
Correct.
So the commission must turn to the person who signed it, which is Advocate Manilal, together with his investigator as reflected at page 3527, Mr. Brian Padiachi, who's the senior investigating officer. The answer must lie between the two of them.
Correct.
We shall do so. Thank you.
Maybe just to complete this, you will see in the last 2 pages that the SAPS does indeed respond, and now we know Mr. Manilal and IDEC have the names of the people that effected the arrest. You see that at page 3532 and 3533. So whatever purpose he sought these names for, he has now been given the names, and maybe he'll come and tell us what he did with the names. Okay, thank you.
And having worked through these documents, did it happen often when you were the ID that investigations are initiated without your knowledge? You will recall that I think when we started our engagement last week, I had expressed a concern that it sounds like everyone within IDEC was on a frolic of his own and running their own show. And this is one such case that brings that to the fore. I want to know, are there many of such, to your knowledge, that are perhaps lying about in IDEC? If this particular summons is anything to go by, I would suggest that they should be.
In all fairness, Chair, there's the teams work within a very structured approach with their matters. They won't come to me with every section 28, but the 28 has to have purpose, and I haven't stumbled across one where even when we have a discussion, then it's out of sync. Sometimes they may have asked for something extra or something less, but it is within the framework of what they were allowed to ask in order to further that investigation. And where I have to make a slight qualification is, I'm not sure what drove this, and so they would have to answer, why would we need that information? Where does it take the Adams complaints, regardless of whether we've put them now to the side and whether the Section 27 is substantial, insubstantial. What will we do with this? What do we do with this?
Where could it possibly take the Adams complaint?
Nowhere. As we have it,
yes.
Nowhere. And that's why I'm saying, they've now, Commissioner Baloy has shown at the last 2 pages, having all these names and knowing whether approval was granted or not, knowing whether it cost 5 cents or 5,000 rands, does not take the Adams matter or matters any further than before he got arrested.
And knowing who from Pktt effected the arrest as well,
Yes.
doesn't take
The matter any
investigation.
further.
No, so is it your testimony to this commission that this actually was the first time such occurred? Can you confidently say so? And if the answer is potentially yes, what would give them, should I say, the strength or the bravery to do just what they did in May 2026? How do you land there as the ID? And I will add to that, if I may. You've been an ID for a few years. If you were in office, what would be the consequences of this?
Well, first of all, they would have to explain why they went off investigation. They'd have to show where it was in the investigation plan.
And where does that help you if they've gone off
And
investigation?
if they have gone off investigation, then steps would have to be taken because...
No, sorry, I apologize. You start by saying why they went off
Yes.
investigation, and I'm saying the why is irrelevant. Based on your and my discussion, we've established that there was no such investigation that can justify this summons. Now, I'm interested in consequence management.
So in terms of the consequence management, either I'd have to first determine if this was the first time, and hope to God that it is. But if it is, then it is a matter of him being given a written warning, or this actually, in this way, and now that we do have the IDAC judge, is to perhaps refer it there because this is irregular and unprocedural in the manner in which it was done. It didn't have we kept talking about the Section 27 as a basis for things. Where's the basis for this? So what is the process you follow when you don't have a basis? And why did you embark then on a process that isn't allowed when you do not have a registered, whether it is an inquiry or an investigation or an authorized matter? And that would be something that would have to be escalated for an investigation outside of the framework of IDAC, which is the IDAC judge.
Is the truth not?
Sorry.
Without taking issue with Ms. Silo's focus, I want to suggest to you that the why is actually relevant because these many, and underline many, departures from the norm may actually be symptomatic of improper motives on the part of IDAC. Do you accept that suggestion?
I accept the suggestion.
Thank you.
Thank you, Chair. And if I may just go back on what you said, is this a question of improper investigation or outright unlawful? It's an unlawful investigation, if not in terms of Section 27 and Section 28(1). We settled that on the first day. So how do you even suggest giving a written warning for unlawful conduct? IDAC is a super powerful institution. It's the only institution in the country which has got the power to both investigate and prosecute.
That is why I corrected myself and said, actually, this matter must go to the IDAC judge because you must first look at the basis, and there is no legitimate basis. Therefore, process of IDAC has been deviated, and for the judge to then consider that.
Where is the ID in this? At which point the ID institutes at least disciplinary proceedings with a view to terminate the employment of these people who abuse the immense powers held by IDAC to do what they did here in Section 28. Why must the judge deal with those issues?
So in terms of the disciplinary processes for IDAC, they now resort under the judge. Judge will look at it. Judge can then recommend to the labor department. Ordinarily, Chair and Commissioners, we would send it to two places, Office of Ethics and Accountability and to the Labor, and they would run the parallel matter. With IDAC, the IDAC judge oversees the IDAC staff. He is the first port of call. You refer matters to him. He can then decide, look, we're going to proceed on this part, look at criminality. In the meantime, Labor, You can institute action because this is clearly a labor issue, but it is looked at holistically, and the judge engages both the Office of Ethics and Accountability as well as labor. But he is the final arbiter and the conduit through which these matters go.
Can I just add that, you know, it's not just irregular, and I think you will agree with me, it's not just irregular, it is in fact an abuse of the Section 28, 6 and 7 power and process. So it's much more serious than an irregularity. Yeah, an irregularity can be, some irregularities can be, condoned, can be excused with an "I'm sorry, you know, I misunderstood." But this is an outright abuse of a process that is prescribed by law for ulterior purposes. You accept that?
I accept that,
Yeah.
Commissioner.
Thank you.
Thank you, Commissioner Baloy. And you, on your first day of testimony, you touched on this section, Section 29, capital A, which reads, an investigator may, subject to the control and direction of a head of an investigating directorate. In this instance, where is the ID's control and direction? When you have a patently unlawful Section 28, presumably informed by an unlawful investigation, and your solution is to direct it to the judge, where do you exercise that control and direction? Unless it has to then be accepted that that investigation was done, that unlawful investigation was initiated and implemented with the concurrence of the ID, because the solution that you offer somehow takes the head of the investigating directorate out of the picture and absolves them of responsibility. Yet the very section you relied upon, I think on your first day, Section 29, capital A, sub 1, says every investigator may, subject to the control and direction of the head. Where do we find that control?
In this instance, we cannot look for the control of the investigating director because it is done without the knowledge of the investigating director. So I had no control over this situation.
So the ID failed to exercise control over the institution?
The ID cannot fail to exercise control over that which she did not know. It has now come to my attention, and then we exercise control in the manner in which I suggested, Commissioners, that it then be escalated to the IDAC judge.
Okay, I would like to move off this topic to a slightly different one, and for that purpose, I would invite us to go to file 3, where we are in the ad hoc transcript. I think I'm not closing file 9 yet. No, I'm not. In particular, please go to page 586. And midway there, page there, this is an engagement you had before the ad hoc with Mr. Ngola. And I'm reading from, I think, literally midway, where it says, there is an allegation, Mr. Ngola says, there is an allegation that IDEC actively participating in a well-coordinated attack against General Mkhwanazi, General Masemula, and General Khumalo. Are you aware of that allegation? To which you respond, I've heard the allegation. There is no truth to the allegation. There are criminal matters that are in the IDEC space. If all that IDEC wanted to do was to go out on a witch hunt, nothing precluded IDEC from arresting and placing both Generals Mkhwanazi and Masemula on the court roll when I took office in 2022, or any time from then till now. We did not do that because there was not sufficient evidence in the matters we have. There is also no witch hunt against Lieutenant General Khumalo because there were no matters brought to IDEC prior to the referral by Mr. Adams. And Mr. Ngola asks, do you not think the manner in which the IDEC responded to Mr. Adams' complaints is actually feeding that narrative? Now, what we dealt with in the morning, in large part arises from yesterday, Mr. Adams's complaint, and including this latest Section 28 summons against Pktt, which you had denied that IDEC was investigating, and it turns out that it was. Surely, with the wisdom of our, this is the commissioners and myself, engagement with you, you must accept that Mr. Ngola was right, that the manner in which IDEC responded to Mr. Adams' complaint, at the very least, is feeding the narrative. And based on the evidence, I'll suggest that the narrative is actually true, that there appears to be an active, coordinated attack, at least against General Khumalo. That much we've established. General Mkhwanazi, not yet, but to the extent that he is associated with Pktt, perhaps. General Masemula, we haven't canvassed that. What would your comment to that be?
Yes, I think that if we look at the matters in their totality, and we also look now that this one, Commissioners 3527, really bothers me. Then the assertion that, or the conclusion you draw, makes reasonable sense. And whilst it didn't, and in all honesty, at the time, what I said is exactly how it was. And as you look at some of the things that have now come out from parallel statements, et cetera, there are dots to connect, unfortunately.
Yes.
It's not just 3527 that feeds.
Sorry, Chair.
It's not just 3527 that feeds into that suspicion. There's also the summons that you signed.
Correct.
Where there doesn't seem to be any basis for the inclusion of the Pktt. So that's another dot that feeds into the suspicion of the Pktt being targeted. You accept that?
I accept that.
Thank you, Commissioner Baloy. Staying with the transcript, let's go to page 592. The same point is revisited by Ms. Sangoni. And Ms. Sangoni inquires from you, Advocate Johnson, were you saying that you are investigating General Masemula and General Mkhwanazi, or you investigated them and found no evidence? Your response: to be clear, there was an investigation in which both are implicated, a matter arising out of IPID. There is insufficient evidence for me to move against the both of them. I'll pause there. My first question, what are these matters arising out of IPID, and what do you mean they arise out of IPID?
Council, when you and I consulted, I did indicate that when I first took office in March 2022, there were already some IPID investigators at the then ID, and they had come over with their matters. I sought to find I just want to find a letter that I can ask that it be shared. if I could just first indicate what the letter says, Commissioners, and then I will hand it over for them to just make copies. I did indicate to Council that when I took office, there were IDEC personnel and IDEC matters in IDEC, but it had been borne out, Chair and Commissioners, by a letter written, and this was the only document I could get, and Mr. Sissoko did look for other documents, but he was part of that process, and he would be able to elaborate if there's a need. But my predecessor wrote to the acting executive director of IPID on the 31st of October 2019, wherein the gist of the letter is that there are matters currently in IPID that fall within the mandate of IDEC. And in terms thereof, certain cases have been identified, and the request is for those matters to come over to IDEC together with the investigators who had those matters. At the time, in 2019, we must bear in mind that the ID was created by proclamation. It is not permanent. It is unable to recruit investigators permanently. And so any investigators the ID would have required would have been what they call secondments or duty reassignments. So she asked for these matters to come over and for those investigators to be brought with those matters. And in fact, investigators did come over with the matters that they came over with. And this is the one letter that I could find where the request was made and to whom the request had been made.
Just for the record, who's the author of the letter and who is it addressed to?
It is addressed to the acting executive head of IPID at the time, and it was addressed by Advocate Hermione Cronier, who was the investigating director, commissioners at the time.
Do you know who was the acting executive head of IPID at the time? Does the letter say?
Make copies. Sorry. Apologies.
We can pause.
We'll pause that one, yes. But it would say, from what I then found out, that exercise did in fact take place. And so when IPID came over, they came over, Council, with matters that would have dealt with corruption. And in the main, because they are IPID, it was corruption matters in the South African police services. And much of these were, Commissioner Baloy, supply chain management issues, corruption, PFMA, and all of those things.
Okay. It brings me to a question about which could have been asked much earlier. And it's a question about how IDEC takes over matters from other agencies, matters that fall within the jurisdiction of those agencies. So you took over dockets, for example, the Orlando dockets, the Langlaagte dockets, all of those, they do fall within the jurisdiction of the SAPS.
Correct.
You took them over and investigated them. Now we know that IDEC, in its former formulation, took over matters from IPID, which fall within the jurisdiction of IPID. I imagine there are matters which fall within the Hawks. I don't know if you've taken over any, but which also the Hawks is qualified. Surely there must be a protocol that even if it is a common understanding, not written down, but an understanding amongst the heads of the agencies about what that regulates that ability and power to summon and demand or request, if you like, matters that are sitting, and properly so, with another agency. What is that governs that, and that would have enabled you, for example, to demand, and I use the word demand quite deliberately, to demand the files from SAPS, to take over the files from IPID?
I think it's the protocols with which we had worked over the years, and it became accepted practice. But I do believe that in some instances, and I do speak under correction which ones, there are also memorandums of understanding or service level agreements, just to ensure not just the smooth working, but legitimacy for why we are asking from somebody else. So across the board, there are those working relationships. There's even, for example, a tripartite between SARS, the NPA, and I think the SIU. So they have that.
Yeah, I guess what I'm asking is it a function of, oh, I like this matter, IDEC likes this matter, which IPID is perfectly qualified to deal with? Is it simply IPID, can decide we like this matter, and so we want to take it over, and you write to your counterpart, and you say, bring it over, and they have to bring it over because that's the governing rule, or is it much more nuanced or much more sophisticated than that, as in it must relate to something that you are dealing with, so you don't just go about fishing for people's dockets, but it's related to something that you deal with? Correct.
So if one looks at the letter that my predecessor wrote, she did set out why those matters should come to IDEC. And I would assume that if the counterpart to whom she wrote felt, we get you, but we're on it, we're good. If we need resources, we rather ask you for resources, but we're good on ours. They didn't do that. They gave over the matters, plus they gave over the investigators, their very own resources, to come and do the investigations in the then ID.
Thank you. We'll see when the letter comes back. Thank you.
And it's gone for copying. Thank you. Let's agree on one thing. The files and the investigations are owned by the institution, which has the mandate to investigate. No investigator owns any investigation.
Correct.
So must I take it that the letter, when it does come, is going to specify which matters precisely are transferring from IPID to IDEC, or it doesn't specify which matters, therefore leaving it open to what you often refer to as their matters for the investigators themselves to determine, I like this file, I'm taking this one. What must we expect from the letter?
In this letter, which was the only one I could find, was where she wrote to them, said why it should be in the IDEC mandate, and then identified certain investigators that must come over with the matters. I guess then those investigators already had specific matters that she had identified to fall within the mandate, and they would have come with those. Mr. Sissoko and I tried to look for any other engagements. In fact, he did call IPID to see if they could find their letter where they then say, these persons are coming over with these matters. We don't have that letter. But we have the persons who came over.
Your response also seems to place emphasis on the investigators and their matters. My question places emphasis on the matters. Does that letter identify them? Because when IPID was seized with those matters, it had the mandate to investigate. The establishment of IDEC and acquisition of certain power by IDEC did not strip IPID of its original mandate, as I understand the law, unless you can show me a provision in the Act, in any Act, that stipulates that henceforth the nature of these matters will fall strictly within the purview of IDEC only. I'm not aware of such. So, if it had the authority, even after IDEC was established, it retained the authority. So I'm trying to understand how the investigation then transfers to IDEC. That's why I say the emphasis cannot be on the investigators, it can only be on the investigations themselves. And that letter, I then expect, would have identified the respective investigations that IPID transfers to IDEC, because having effected that transfer, then IPID no longer bears responsibility for the further execution of those investigations and acting upon any outcome.
If I could just look at the. Yes, this. So in paragraph, apologies, Commissioners, in paragraph 3.1, my predecessor writes, with reference to my letter with subject request for a meeting to discuss the operational cooperation between the Independent Police Investigative Directorate and the Investigating Directorate corruption, and there's a reference number and date 16 June 2019. I have identified a number of cases that I understand are already being investigated by IPID. I hope to prioritize them as short-term, medium-term, and long-term cases for the ID. Given the sensitivity of the matters on the list, I propose we set up a meeting to discuss the cases that the ID will investigate within its mandate using the powers conferred by Section 28 of the NPA Act. Now, we couldn't find that letter that she talks of, but she does identify that there are matters that would come. We did look for that letter because I was also confused that there's a whole table setting out who must come, but there wasn't anything about the cases. And then in 2.1, Chair and Commissioners, transfer of the cases mentioned in paragraph 3 for investigation by the ID as specified offences in terms of the mandate of the ID, and the placement of the IPID members mentioned in paragraph 4 for a period of 10 months to conclude the investigations under the auspices of the ID. And then she just set out logistical arrangements. But that list, we were unable to find in our office, and we did ask IPID to look for that list of cases.
Yeah, and because the letter you've given us, as I understand it, at least it identifies the investigators that have been seconded to IDEC, and those are set out in paragraph 4 of the letter. At paragraph 3, there's supposed to be a document that lists the cases currently under investigation by IPID, but which are being requested to be transferred to IDEC. That is the list we don't have.
Yes.
And you say that these investigators came with their investigations.
Yes, which ought to have been.
It can be correct.
Which ought to have been part of the list.
It can be correct. They don't have investigations. They get seconded. Paragraph 3 tells us which cases go to IDEC. There are no their investigations, surely. Because when we express ourselves in those terms, it suggests that these investigators own the investigations, and that is wholly wrong. It's the institution that owns the investigations.
Correct.
So it doesn't mean wherever the investigator goes, that investigation follows them around. So
it's just in the way that it's couched in 5.2.1 and 5.2.2 is that the transfer of those cases will come to the ID for investigation as per the mandate that she alluded to, and the placement of the IPID members as per paragraph 4.
Now let's read 5.2.1 correctly. Transfer of the cases mentioned in para 3.
Yes,
So it confirms what's in paragraph 3. They have to be specifically identified.
correct.
Yes.
And then those persons will be placed in IDAC for a period of 10 months to conclude the investigations under the auspices of the ID. And so I take that to mean that there's a list of cases, and then there are people who will come from IPID to IDAC with their cases, or with their cases.
Yeah.
Yes.
No. Paragraph 4 tells us who is being seconded.
Yes.
Paragraph 3 tells us which cases are being transferred.
Yes.
What we have is the list of secondees. What we don't have is the list of cases.
Yes.
But you want to tie the two together and say those investigators brought their investigation, and I say there is no such a concept. It's specified cases. A list of which we don't have, which you say you could not locate. Which then raises the question, the current cases that are being investigated by IPID, that were originally being investigated by IDAC, thank you, Commissioner. The current cases being investigated by IDAC, which were previously investigated by IPID, those investigations could potentially be unlawful, because they may very well not be part of the list contemplated in 3. And you don't know that, from what I understand. As long as the investigators say, it's my file, it's my investigation, I came with it from IPID, you've accepted that as a correct legal position.
Yes, but from what I also understand is that when these matters came into when the matters came from IPID into IDAC, the matters had to be assessed in terms of whether or not they fell within the IDAC mandate, as she said in paragraph 1.2 and in 2.1. That exercise would have had to have been done. These matters are now here. Do they fall within the mandate? And if they fall within the mandate of the ID, those matters would then have had to be declared in IDAC in order for them to continue in IDAC. And I'm given to understand that in
Yes.
many of those matters, there were Section 28 authorizations for those matters to continue.
Now, I don't understand that. IDAC doesn't operate in terms of Section 28. That's an IDAC authorization mechanism.
Yes.
So we need the first leg for them to leave IPID and legitimately come into IDAC,
Which they did.
which they did. And I would have said, on the basis of that transfer, the investigation continues. It doesn't need a 28-1 to trigger an investigation. The investigation is ongoing, except now it's under a different umbrella. But what I understand from what you are saying, there is absolutely no record of any investigation within IDAC, following your extensive search with Mr. Sissoko, of matters that were lawfully transferred from IPID to IDAC. We don't have that record. That's what you struggle to find.
The list of the cases.
Yes.
Yes.
Okay. We touched on that in passing because we were looking at page 592 of the transcript, your file 3.
Ms. Silla, maybe just for
Yes,
the
ma'am.
record, to mention that the letter doesn't say who the acting executive head of IPID was at the time. Just to complete that question. Yes, Ms. Silla.
Thank you, Commissioner. I note, would you by any chance remember who it was?
No, I had not engaged with that person. I came much later.
Yeah, no, I appreciate. I thought you might know.
No, not at that time, no.
Okay. So I guess it's for us to find who on the 31st of October 2019 was the acting executive director of IPID.
IPID.
Now, And lastly, on this letter, I read is a request to IPID, and you have not been able to locate a response from IPID.
Yes, Mr. Sissoko says he did see a response. He's asked a colleague from IPID if they can find their response, because he clearly recalls that there was a response to the letter.
Where could he potentially be searching? You and I had this conversation over 2 weeks ago. Where could he be searching for this response that it's taken this long?
He's gone through his records, because he's been with the, he has been with
IDEC?
the ID since, I think, September, October 2021. So he's looked in his records and couldn't find it. And so he's asked the colleagues from IPID. And I understand why he may not have been able to find it. It could just as well have been a document that was composed in the office of the investigating director and sent directly through to the acting executive head, IPID.
Now, I see this letter is from H.T. Cronje as the ID of the NPA. Would it not be amongst their records? These ought to be independent IDEC records. They don't rely on anyone within IDEC to have copies. So when you take over from Advocate Cronje, these would be the documents and the records you inherit. And that's where I would have expected the search to happen. From amongst the documents you inherited from Advocate Cronje when you took office. They are not there.
I did not inherit many documents from Advocate Cronje.
I don't know. But I'm saying you inherited documents
I inherited
from that,
yeah.
That resided and belonged to the office, unless you walked into an empty office.
Actually, I did.
Oh.
Yes. Sorry.
So you're suggesting...
That's a fair answer. She asked for it.
Yes.
So then we're suggesting that... How long was Advocate Cronje in office?
I think it would have been April 2019, thereabouts, to February 2022.
Okay, so I guess we'll direct our inquiry to Advocate Cronje to check whether when she left office, she left with the ID's documents, seeing as you walked into an empty office. Yeah, I can live with that, Commissioner Khumalo. Thank you. Having then dealt with the investigations you referenced during your ad hoc hearing, you then proceed with, at page 596 of the same record, and at the top of 596, the conversation is about Mr. Brian Padiache. That's not where my interest lies. My interest is more, let's look at the question by Mr. Skosana, the third question, fourth on that list, midway the page. Mr. Skosana says, were you only aware of the Medicare contract in February? You say yes, when it was referred to IDEC. This is February of which year? Do you see where I'm reading?
Yes, I see where you're reading.
Yeah, we are now in November 2025. You are before the ad hoc.
Yeah.
Just to give you pointers.
Were you only aware of the Medicare contract in February? Yes, when it was referred.
Well, it can be 2024. I'll offer you that.
It's 2020.
It can be 26 because we're in November 25. I suggest it should be February 25.
It was 25.
Now you say when it was referred to.
Sorry, I get a bit slow by the afternoon.
I know.
Like yesterday, I'm sorry.
You and I both, don't worry. So we are now in February 2025. You say that's when it was referred to IDEC.
Correct.
I have a challenge with your timeline.
Okay.
When it was referred, I take it is a Section 27 referral. That's what we mean when you said it was referred to IDEC.
Yes, that is correct.
This, just for the record, the advertisement for that contract was in January 2024. The award or the contract was the 14th of June 2024, and it was signed on the 18th of June 2024. Now, what I have on record is file 9, page 3519. And my reading of that document is it's an affidavit. If you run ahead to page 3521, it's signed there and commissioned and I see the date attached there is the 6th of June 2025. My interpretation of this document is, although it doesn't say on the face of it, that it is the referral. And at paragraph 3 thereof, Miss Charity Matlala Matlou, who says she's a Major General in SAPS, the component head Risk and Integrity Management. At 3, she states, I hereby submit this affidavit to the Investigation Directorate Against Corruption in support of initiating a criminal investigation into the alleged unlawful awarding of the Medicare 24 Tshwane District Pty Limited. Then it gives the detail. So on a reading of this, it would appear that the referral was in June 25. Why did you suggest that it was referred in February 25, as you did before ad hoc? What were you basing yourself on then?
I know that they... I know that they referred the matter earlier in that year, and the general was then asked to depose to an affidavit in terms of Section 27. That is my recollection of the matter. They wanted to refer the matter to IDEC, and we then indicated that in order for the matter to be referred to IDEC, she would have to depose to an affidavit for that referral. And that would then be this. Sorry, Council.
No, apologize. Please conclude.
Yeah,
I thought you...
So that is how I have that sequence in my head.
So what did you receive in February then to understand for the affidavit to only come 4 months later?
From what I understood, she's at risk and integrity management at the police. They wanted to refer the Medicare matter to us, and we indicated that they would have to put a Section 27 affidavit together to refer the matter to us. I cannot tell you why she took so long to do that, but there were discussions initially about there is this matter and we want to refer it to IDEC, but we were not going to be able to take the matter as is to IDEC without the referral.
But still, then you would not have been correct to suggest to the ad hoc committee that there was a referral in February on that version alone.
Yes, on my version, it is, maybe I should have said it differently, but on my version, we had engaged on a referral of a Section 27 to IDEC for the Matlala matter, and that was done in around about February.
What do you mean you had engaged in a referral? I don't understand.
Sorry, we engaged about a referral of a Section 27 to IDEC in February.
So then I would expect, and perhaps it will go into our list of
and
documents.
maybe I must pause here. I speak under correction, but I think that what might have preceded this was a letter. For some other reason, as I look at this now, there was a letter indicating that there's going to be a Section 27 referral to IDEC. We indicated that that is insufficient, and if I'm not mistaken, that would have come from General Dimpane, I think was the CFO at the time, and we then had to indicate that it would have to be an affidavit. I will look for that letter and ask the prosecution team this afternoon, because for some other reason that is a bit more familiar, that we had a document that said we are referring this matter to IDEC in terms of Section 27.
And I take it now that letter, in order to get to a point where an affidavit is submitted, that letter would have been responded to in writing.
Yes.
So should I expect a response that says, please have regard to the provisions of Section 27, these are the requirements, something along those lines? And if there isn't?
And if there isn't,
you won't be around for me to ask you. So.
No. So I can give you a possible scenario if there isn't. If there isn't, what it would have been is I would have asked Mr. Perumal, who worked quite closely with General Matlo, to make sure that this letter is not sufficient for purposes of a referral. Kindly ensure that they follow the prescript and give us an affidavit.
But then Mr. Perumal would have dispatched such a letter. Is that what you're suggesting?
Either verbally, or there is a letter that was dispatched. And that is why I wanted to say, if you can't ask me later, that if there isn't a letter, there would have been an engagement.
This is the second letter that is received by your office, and there is no record of a formal response thereto. What in fact happens is heightened activity regarding investigations resulting in prosecutions. That's rather lax, is it not?
No, I'm not saying there isn't a letter. You asked what would the possible scenario be if there isn't a letter, and I'm not here to ask. I'm saying that the letter would have come from General Dimpane's office referring the matter to us. We would have acknowledged receipt of the letter, and whatever else would have been written in there. I will most certainly ask the PA to check for that.
So then the answer must be, if you received a letter, because that's a trigger, then you would formally have responded to it,
in a letter.
And all those records are within IDEC.
And
you just tell us who to turn to establish those facts.
Okay, so those two, I'm going to the office tomorrow to pack up my bags, but I'm able to ask
Please.
My PA, the PA that was my PA.
Yeah.
Before
Understood.
someone says I'm taking ownership of people in IDEC when I'm no longer the ID chair, I apologize.
Okay. So then you went through that process, and we landed in June 2025 with this affidavit.
Correct.
Which you consider to be a Section 27 affidavit.
That is correct.
I look at first page 3519. We read paragraph 3. Paragraph 5 then informs that a comprehensive internal audit report is currently being compiled, which will shed further light on the alleged criminal misconduct, the procurement processes which were flouted or manipulated, and other relevant aspects. Thus far, in this affidavit, I haven't come across any alleged criminal misconduct or an allegation of flouting or manipulation of procurement processes. At least those don't precede paragraph 5. They can only succeed it. You accept? Because the author, the deponent tells us that a comprehensive internal audit report is currently being complied, which will shed further light.
Yes.
So it suggests that at least at a superficial level, established an alleged criminal misconduct, the procurement, flouting of procurement processes and or manipulation of such processes and other relevant factors.
But in paragraph 3, she says, in support of initiating a criminal investigation into the alleged unlawful awarding of a tender, that's the first one that she starts with, to Medicare 2024 to provide medical health care services value 360 million.
Yes.
2, I reasonably suspect that procurement processes may have been flouted or manipulated to the undue advantage of Medicare. And then she says, I also suspect that corruption and money laundering may also have been perpetrated to the prejudice. So she does set out.
I take the point. Then let's go over leaf. It sounds much like Mr. Adams's affidavit. At 6, she states on the 14th of February 2020, and at the end of that paragraph, she also has 2020, but I think that's an error, because I think that contract was advertised in 24.
23, 24.
Yeah, I take it just a typographical error. And until told otherwise, we will perhaps make a provisional amendment. 7 then touches on her suspicion that Mr. Matala has questionable ties to members of SAPS who unlawfully assisted and favored him during the procurement process. Mr. Matala misrepresented in the bid documents that he did not know any officials. Then at 8, says, I've advised the National Commissioner General Masemula of the SAPS that he should consider terminating the contract with Medicare to save the SAPS from irreparable harm and to diminish the financial prejudice being suffered by SAPS. General Masemula ultimately terminated the contract with Medicare on or about the 15th of May 2025. By that time, SAPS had suffered prejudice of approximately 50 million, and concludes at 9, nobody has the right to defraud and commit crimes against the SAPS, and I therefore report this matter to IDEC to conduct the criminal investigation. So what we can deduce from this affidavit is at least the Section 27 is referral affidavit is filed after the contract was terminated. It, in essence, alleges, or at least expresses her suspicions that it was unlawfully awarded, that the beneficiary, Mr. Matala, has questionable ties to certain members of SAPS who unlawfully assisted and favored him during the procurement process. And that, you know, some members could have, I guess the procurement process could have been colluding with Mr. Matala. That's at paragraph 7. This is June 2025. We are back to Section 27. We are back to there not being any grounds. We are back to the deficiencies that we have discussed. On your reading of this referral affidavit, was it sufficient to authorize an investigation?
Maybe before you answer that, let me ask the question. In 5, the general refers to an internal audit report. Has that been received or sought by ADEC as part of its investigation?
Yes.
And you have that?
We have that.
Okay. All right. You can answer, Mr.
So, based on the reasonable suspicion, I think there's enough that makes out the reasonable suspicion.
What makes out basis for reasonable suspicion?
in terms of what is set out, and this, where I did not quibble, council, with the 27 as it was in Adams, this is more substantial. I know it's a difference of opinion, but I'm saying this is more substantial. She does allude to the alleged unlawful awarding
As you said, you remember that the unlawful awarding, that's a conclusion of fact. And that fact must be premised on a certain grounds.
Yes, which is now not going to add in the 27. The unlawful awarding of a tender to Medicare to provide medical health care services for a period of 3 years. So she says the tender one is unlawful.
I would expect you during the course of that exercise to at least tell me where in this affidavit she states the basis for that conclusion.
I reasonably suspect at 4 that procurement processes may have been flouted.
Okay, which then invites me to say on what basis does she suspect, reasonable or otherwise? Where in the affidavit does it tell you that?
I reasonably suspect that the procurement processes may have been flouted or manipulated to the undue advantage of Tswane Medicare 24 and its sole director, Vusimuzi Matlala. I also suspect that corruption and money laundering may have been perpetrated to the prejudice.
Again, we are in the realm of suspicions.
Yes.
On what
Still in the
basis
realm.
is the suspicion based?
From my reading, when you look at paragraph 5,
Let me explain. I'm not saying she's not correct. I'm not. I'm looking at this document from IDEC's perspective. When somebody tells you of all the suspicions they have in the world, to entitle IDEC to do something about it, to act, when an affidavit purports to be a Section 27. So she could very well be correct in everything she's got here, but it's a question of whether the disclosures were sufficient to trigger an IDEC investigation within the contemplation of Section 27.
and I'm saying that if you look then, Council, further at paragraph 5, the comprehensive internal audit report is currently being compiled, which will shed further light on the alleged criminal misconduct, the procurement processes she refers to above, which were flouted and or manipulated, and other relevant aspects. The said report will be made available to IDEC in support of conducting criminal investigations into the allegations. So she lays the basis for these within the comprehensive internal audit report, which is going to be making available. And sorry, Chair.
Advocate Johnson, you remember the debate we engaged in, I think it was the very first day of your testimony, and we engaged you on factual conclusions.
Yes.
And on facts that support or undergird those factual conclusions. You remember that?
I do remember, Chair.
Yes. I don't quite see why what you've just read now are not factual conclusions. And what Ms. Silo is engaging you on is tell us the facts that support those conclusions. That's the substance of the question. Unless you are saying what we see here is not the same or similar to what we engaged you on your first day of testimony. I will tell you outright that I see these as factual conclusions as well. And the reference to reports that perhaps may better inform the conclusions, reports that are yet to come, cannot cure the deficiency.
I understand.
Do you agree?
I agree with you.
Thank you.
Thank you, Chair. Now, staying with paragraph 5, we know that she tells us that the internal report was being compiled at the time she prepared this affidavit. Was IDEC ever finished with such? And if so, when?
I will find out. I'll find out this afternoon still.
And as you find out, please check and confirm that it definitely was not earlier than the 25th of June 2026. On my record, that was furnished to IDEC in June 2026, the latter part of June. And if I am correct in my understanding and accepting, as you have, the deficiencies that beset this particular affidavit, then once again, the challenge is the basis for initiating the investigation in the first place. And I think, if memory serves me well, by June 2026, there had been arrests. We're in July 26?
Yeah, was it not before?
There had been prosecutions, initiated arrests,
Sorry,
and summoning
I
of,
think it might be April, May?
I
Speak
put
under
a
correction.
date for you to cross-check.
Yes.
My record would seem to suggest June 26. And I'm saying by
No,
then.
They appeared again in June, if I'm not mistaken. But
No,
I think the first appearance was
I stick to my date that audit report was made available to IDEC no earlier than June 2026.
Okay.
Now, if that report was intended to shore up this Section 27, then I would have expected investigations to stop or not be initiated pending receipt of the report, the audit report, because that would tell you, give you some facts to determine whether or not your mandate is met. But based on what we know has happened, it sounds like, it would appear like, and that's how it appears, I'm happy to be corrected. Upon receipt of this particular affidavit, investigations were triggered, resulting in arrests, and I think appearances in court already. And after all that happened, then the internal audit report came in.
I will have to find out.
Assuming I'm correct in my assessment, I guess you know where I'm going with this.
Oh, yes.
Okay. Now, this is particularly interesting because this contract, yes, was engaged with to some extent before the commission, and that could potentially have been a source of information for IDEC. But absent a valid Section 27 affidavit, that information would have had to be held in abeyance until your own investigation is formalized and not acted upon. Now we know at least it culminated in the arrest of a couple of people, but I'm interested for the moment in the summons of General Masemola. You recall we started at page 586 of the ad hoc, where Mr. Ngola asked you whether there is a coordinated attack by IDEC against Generals Masemola, Kumalo, and Kwanazi. And I think it was Ms. Sangoni as well asked about the investigations against Masemola and Kwanazi, and you said there was nothing at the time. This is November 2025. Just if you can go back to page 592. we looked at it earlier, midway that page. If my timing is correct, this is November 25.
May I just quickly,
Yes.
Find out whether Mr. Michaels shared what he just gave to us with Mr. Bodlani and his team, please? Thank you. Sorry for that.
Thank you, Chair.
Thank you.
It's a different issue. It will come to you, Advocate Johnson, in a short while. If we could turn our attention to page 5992.
In fact, with Advocate Johnson as well, please, if there's a
Yes.
copy to spare.
Where is that? We'll turn our attention to that in a moment, Advocate Johnson. It's the exercise that
That the chair had asked, yes.
had asked us
I
to
will be
do.
coming back to you with my questions on that. Thank you.
Okay. I just want to wrap up this issue. So now you are at the ad hoc in November 2025. You are specifically asked whether there are investigations into General Masemola and General Mukhwanazi, and you said, apart from those inherited matters from IPID, there are none. One of two things, you might be correct that there were no investigations into both, insofar as the Matlala contract is concerned. Regard being had to the fact that you received the affidavit in June, or you might have misled ad hoc when you at least claim that General Masemola is not under investigation for anything. Because for you to have been correct, it would mean General Masemola's, I'll take it, involvement in the corruption relating to the contract came to the fore, insofar as IDEC is concerned, only after November 2025. Would that thinking be correct?
At the time when I was at ad hoc, he was not the subject of the investigation.
That's a fact, okay.
That's a fact.
All right.
And
So-
it is much, much later on in the investigation that it came to my attention that he is now a subject of the investigation.
And that would definitely not have been on the strength of the internal audit report, because on my contention, that audit report was availed to IDEC in June 2026, and by then they'd been charged already. So there's another basis on which IDEC relied to impugn wrongdoing on his part and I'll accept after November 2025.
Correct.
That's a summary, okay. Chair, before we go forward and deal then with some detail as regards this, perhaps the chair would like us to deal with the issue of the Pktt and the disbandment or purported disbandment, whatever the correct legal position is, of the Pktt. The chair had requested that we scan the landscape and try and determine the extent to which this matter was addressed in the public domain and in newspapers. And we are indebted to our head of communications, Mr. Jeremy Michaels, who undertook this massive task for us. You have before you, Chair, a summary prepared by Mr. Michaels on this question. And Chair, I'll leave it to you. Thank you.
Thank you, Ms. Sello. You signed the summons we were debating, the summons which at paragraph 6 of annexure, is it annexure B? Yes.
Yes.
Refers to the Pktt. And when you were engaged on this, you suggested that you would have to, or rather people who would have to answer to this were those that made the recommendation that related to this part of Annexure B. And this was on the basis, as I understood you, that you were not quite sure of the issue that related to the Pktt. Am I correct in my summary thus far?
You are correct, Chair.
I specifically asked you whether, if you were aware that there was an issue around the Pktt and its disbandment, you would not have been alert in your mind and raised specific issues with regard to this paragraph 6. And you said you would. I also asked you about whether, if this was publicized, the issue of the purported disbandment or disbandment of the Pktt, if it was out there, whether you would have been aware of that. And you said you would have been. And I even said to you, I hope that your escape route will not be that, oh, it was only publicized by such and such a media house, I don't go there at all.
No.
And you said, I read all media.
Correct.
Now, let us have a look at what you have just been given. There it opens with, there were numerous articles in broadcast, electronic, print, online. I'm not sure what the difference is between electronic and print. I'm not a media specialist. Regarding the disbandment of the Pktt. And this goes further and says that there were even social media posts on the subject. And the period is from 1 January 2025, the 1st of January being the very first day after Minister Mkhunu's late night letter of the 31st of December 2024. And this goes on and says the wide coverage covers the period up to 15 April 2025. You see that?
I see that, Chair.
Would you say that what's been captured in this document is perhaps inaccurate, or would you accept that it must be accurate?
I would have to accept that it is accurate.
Now, you said that you do follow media publications, so you must have seen publications around the disbandment of the Pktt, correct?
Correct, Chair.
And you would also have seen that it was a controversial subject, correct?
It was, yes.
It was. Now, this takes me back to my question about paragraph 6 of Annexure B. Why is it? Because you suggested this morning that no alarm bells rang in your mind about paragraph 6. Why is that so? If there was such wide coverage of this subject, a controversial subject, why did alarm bells not ring in your mind? And why would you, in those circumstances, not have asked, but what's this got to do with the Pktt? What the investigations that we are embarking upon as IDEC, what have those got to do with the Pktt? Why was your mind not put on an inquiry in that regard?
I do not dispute the information, and I do not dispute that I should have asked questions. I don't know what questions I asked, if any. And so I take it that, Chair, I signed it as I signed it.
This morning, you can't get off that easily, Advocate Johnson. This morning, you basically suggested that you were not really aware that, as at that time, at the time you signed this summons, you were aware that there was any issue about the Pktt.
Correct.
And also that not only that, but that the issue raised some controversy, correct?
Correct.
Now, as someone who follows the media, and with such wide coverage, and with you now accepting that you would have seen this, I want to understand why no alarm bells rang in your mind with regard to this issue. A very crucial issue affecting the criminal justice system. Why is that so? Or why was that so, as at the time you signed the summons? It cannot be enough to just say you just signed. That's not enough.
No.
Why did you sign on something that's controversial, or that was controversial at the time? Why did you just go ahead and sign?
It is one of two things, and it's not an excuse, Chair. Either I engaged and was engaged with Mr. Perumal and was satisfied with whatever answer I got. However, it comes back to what I said. I was unaware of a Pktt investigation, and so I should have asked deeper questions. I cannot tell you why I didn't ask deeper questions.
Exactly continue,
sorry.
continue.
And what I'm saying is I'm not looking for an excuse for, I'm saying, should I have? I appreciate that I should have, and that I didn't ask deeper questions, and I did sign it. I cannot get away from the fact that I did sign it.
It's crucial that you say you were not aware of a Pktt investigation. And this was an issue that was topical, and not only topical, but also controversial, you've accepted. So you are not aware of a Pktt investigation as at the time, but you go ahead and you sign. That's very difficult to understand. And unless there's something you are not telling us.
Not at all, Chair. And when you look at the sign, that document talks to, I think it talks to,
Three.
When we look at the top, Chair, paragraph 1 talks to the deviation of appointment of Lieutenant General Commando. And when I looked at paragraph 6 during one of the breaks, the original, the original documentary files and applications for promotions of the commanders and members of the political killings task team through deviation. They tied in to the deviation process. But that doesn't take away, again, Chair, it doesn't take away from the fact.
It doesn't address what I'm raising with you, which is at paragraph 6 of Annexure B. That simply does not answer the question. Does it?
I dealt with it as the deviation, but I'm coming back to what Chair is asking.
Yes, I'm asking you about paragraph 6 of Annexure B. What you just read now does not address that.
I understand.
That has nothing to do with deviations, which we've just referred to. This is about inquiring into promotions of commanders and members of the Pktt. So the entire body of the Pktt, that has nothing to do with the deviations you've just referred to. So you've not answered my question.
Chair, I can't take it further than the answer I gave. I should have asked more. I don't have a sinister reason for not having asked more. I didn't ask more.
All right.
Whatever the discussion we may have had, I accept your point that I should have asked more, so why didn't I? And I don't have an answer for why I didn't ask more, or why I don't have a better explanation. I can take it only so far.
Yes. Let me.
I want to suggest, as you continue with the chair, that another possibility is you knew what this was about. And you knew exactly why the Pktt is in that paragraph 6. That's another possibility. Sorry, Chair.
No, it's okay. That's exactly why I even asked, isn't there something you're not telling us?
Not at all, Chair.
But can you answer the question raised by Commissioner Baloyi directly? You heard it.
She'll repeat for me. May, please repeat.
Yes, I was saying, well, the other possibility is you knew and understood why the Pktt was in that paragraph 6, or why that paragraph 6 was in there.
It's simply inexplicable. It is simply inexplicable that you would not have addressed this. Not when you accept that this was not only topical, but it was also controversial. So alarm bells should have rung in your head that you did nothing. What that tells us, subject to your response, is you must have known what was going on, or not?
Chair, I can't take it any further. I accept your point.
You accept that
I accept your point because
that you knew what was going on.
I must have known because there's nothing else I have to gainsay it. I followed your logic.
Yes.
And what I'm saying is, in the absence of something to gainsay it, I'm going to be talking in circles and rambling on at this part of the afternoon, which none of us want.
If you knew it and it had nothing to do with what was being investigated, you've said in so many ways that the Pktt was not being investigated. So if you knew, why did you sign this when it included something about the Pktt which was not being investigated? If, as you say, you knew about it. Or at best for you, you must have known about it.
At best, I must have.
So why did you sign it? You know that the Pktt is not being investigated and you accept that you must have known. Why would you have signed this? Why did you not cross out number 6 of Annexure B?
I know it may not make sense, Chair, but I followed the line of what they were asking. And for me, it went back to promotions of the commanders and members through deviation, because we were dealing with deviation right from the top, and we were dealing with appointments.
That's still, finish.
Sorry, that is how it followed for me. I accept it may not make sense to anybody else, but I followed that sequence of appointments, deviations. There are allegations that there are promotions of the commanders through deviation. We were talking about promotion of an appointment of Lieutenant General Khumalo by deviation. So it made sense in that regard. But what the questions were that I asked,
That reasoning simply does not make sense, because 6 is about the entire complement of the Pktt. You would have to be suggesting that you thought that deviation applied throughout the entire complement of Pktt, which simply does not make sense. You could not have believed that at the time. So your answer is a non-answer, Advocate Johnson.
Chair, I agreed with you and I'm sticking to that agreement.
You agree even with the last proposition?
I agree with your last proposal. I can't come up with something different in my head at the
Yes.
moment. This happened early last year, early
Yes.
last year.
Yes.
I have no other recollection or something to trigger my mind. I did think that by talking to Mr. Perumal, it might have triggered my mind. I'm not saying I would have come with a better answer, but that is the answer I have to
The problem,
make peace with.
the problem, just to add with a deviation point, is that as you read it, it's person-specific. That's number one. Number two, when you look at number 6, it's
Quite wide.
Not just wide, it covers the the entire spectrum. It refers to all Pktt members, from commanders all the way down to the most junior. It covers, so for that reason, you just cannot rely on the point about deviation.
I accept the chair's
Yeah.
proposal.
Now let me make a different point. Having seen what we showed you now about publications, and with you having said you do follow the media, I want to suggest to you that you were not truthful when you suggested that you were not really aware of any issues around the Pktt which would have caused alarm bells to ring in your mind. That is why we went into this exercise of finding the extent to which the issue of the disbandment of the Pktt was publicized. So for you to have even suggested that, no, alarm bells could not have rung in my head, to have suggested that when in fact it was publicized as widely as it appears to have been, you were not being truthful this morning.
No, Chair. The alarm bells not going on does not take away the fact that I may have seen some, if not all of this. There were no alarm bells for me and for IDEC. This had been it was a police matter at the time that it was being canvassed. We were not working with the Pktt at the time. I have colleagues in KZN who work with them. But the alarm bells didn't have to go on because it wasn't within our space and it didn't affect any of the work that we were doing. So, of course, there's a lot of discussions, Chair, some unpleasant, and there was a lot of toing and froing between the police and the police ministry and the provincial head for KZN. That was alive and clear, but it didn't raise alarm bells for IDEC at the time.
It should have, exactly because this was topical, this was controversial, and you say, as at the time you signed the summons, you knew that there were no investigations against the Pktt. So your mind should have said, hey, this thing is so topical. What's being said here about the Pktt? It's in that sense that I'm raising this with you, and I'm suggesting that you were not truthful this morning.
No, Chair, I stand by what I say about it didn't raise alarm bells for me. I appreciate your point, however, that it should have. I didn't misconstrue anything I said. I appreciate the different view, and I accept your different view. But it didn't raise alarm bells at the time.
I must just conclude this by saying I find it strange that it didn't, as you suggest, it did not.
And I take note of you, Chair.
And subject to our further weighing up of the evidence, let me outright say that I find it hard to believe what you are saying in this regard. Your comment?
It's up to the Chair and the Commissioners.
Thank you very much.
Advocate Johnson, I need to take you back to the two main questions that were posed to you in the summons. And you answered them in paragraphs 8 to 10 of your supplementary statement dated 10 July 2026. And question 2.1 was about whether IDAC has acted within its mandate. And you said IDAC operates strictly within its mandate, and you set out what the mandate is. And then in paragraph 10, are you there?
Sorry, Chair.
It's page 4 of your supplementary statement. Are you there?
I'm at
Yes,
page
so
4.
paragraphs 8 to 10, you were responding to question 2.1 in the summons. So paragraph 8, IDAC strictly operates within its mandate, and then paragraph 10, IDAC has not dealt with matters outside of its mandate. Now, do you stand by those paragraphs in light of the discussion you have had with Chair and Commissioner Baloy? And in light of what we have discussed for most of the day, the various cases that IDAC has dealt with, at least in the last 2-3 years.
I stand by paragraph 9 because it deals with the commissions.
No, that one is
That
clear.
is fine.
That one is clear. 8 and 10.
Item 10.
Can you still say, after all we've discussed, that IDAC has not dealt with matters outside of its mandate? Can you still say that?
No, Chair.
Can we,
Chair, before
yes.
we break perhaps for a
yes.
short breather and to determine how far we take it today, may I just finalize in one issue with the witness,
Right.
which is relevant to, to the discussion that the chair...
When we take that adjournment, if between you and Mr. Bodlani, you could have a discussion and then come to us outside, just
Indeed.
indicate how long you think will still be.
Indeed, Chair,
Thank
shall
you.
do so. Advocate Johnson, I would like to take us back to the note that our head of communications, Mr. Michaels, assisted us with on the issues raised with you by the chair. And if we look at the bullet items, these are the various publications on the matter that the chair has engaged you on, starting from the 2nd of January to the 22nd of January. Now, that's about a period of a month, a few days shy of a month. And you're suggesting you never saw any of these articles regarding the disbandment of the Pktt.
No, that's not what I said.
Okay, correct me, please.
Sorry, I did say I have read about the Pktt. May not have been necessarily all of these, but it was clear out in the media that there was an issue with the Pktt, there was an issue with the minister, there was an issue between the minister and SAP's counterparts about the disbanding or potential disbanding of, that's the summary of which I'm very aware was being played out at the time.
Now, by SAP's counterparts, you mean strictly within the SAP's
Within
environment?
the SAPs,
Okay.
yes.
Between the 31st of December, when the minister issued his letter, until April 2025, did you ever have opportunity to meet with the minister and discuss these matters,
Of the Pktt?
including Pktt?
No.
Did you meet with the minister in that period, and if so, for what purpose?
Sorry. Just be clear which minister.
Minister, it's not former. Minister Mkunu, for avoidance of doubt. Minister Mkunu, I mean.
I cannot remember when but Minister Mkhunu called myself and the head of the DPCI to a meeting. And there was a matter that he wanted to raise. It had nothing to do with the Pktt. In that meeting, I informed the minister that unfortunately I report to the Minister of Justice, and that this matter, if it had to be dealt with, can it please be dealt with by General Labia? And then I asked if I could be excused, and they carried on with the matter.
Was that the meeting of the 21st of January 2025?
I honestly can't remember the dates.
Now, you have to at least give January 25, February. Remember, I used the articles as a pointer, and the point at which Pktt was disbanded. Now, I want to know when you met with the minister after the disbandment of the Pktt. And I'm asking you whether it was on the 21st of January 2025. If you can't exactly recall, you can't suggest that it might have been in September. No.
No.
Maybe not 21st, in January 25. I'll land it there.
What I'm saying is I can't dispute your date because I can't recall the date.
Okay.
But what I'm telling you is who was at the meeting, that the meeting was about some other criminal allegation. I then indicated I'm unable to deal with it, and IDEC resorts under the Minister of Justice, and I left General Labia with the minister to deal with the matter and to finish it up. Later, General Labia did indicate that DPCI will deal with the matter.
And in that meeting, I attached the date of the 21st of January. Is it your testimony to this commission that the issue of Pktt neither arose nor was discussed, whether in detail or otherwise?
Not in my presence.
Not in your presence?
I wasn't there for long.
So should a witness come before the commission to state otherwise, what would your view be? Are they misleading the commission?
Yes, I can't remember discussing the Pktt with the minister.
No, you would know definitively whether or not you did, regard being heard to your response, that the matter that the minister wanted to discuss with you concerned mainly the DPCI, and because you report to the Minister of Justice, you then excused yourself.
Yes.
So knowing precisely what the meeting was about and circumstances under which you left the meeting, you ought to know whether or not you discussed the issue of the Pktt with the minister. If you are still unsure, then that suggests you may potentially have discussed the matter with the minister, but on a different date, which then would invite me to ask you on which date then did you have a meeting to discuss, amongst other things, the Pktt with the minister.
I recall having one meeting with the minister and his chief of staff, and then there was that second meeting that I had with General Labia. The first meeting that I had, from my recollection, the minister wanted to meet and greet, and he talked to me about IDEC. I can't remember that date. I'll have to check that date. But I can't recall talking to him about the Pktt.
Did you?
And if somebody says I did and they were there in that meeting, then they'd have to refresh my memory.
Okay. Did you discuss Medicare, the Medicare contract?
No.
That too did not feature
not
on
at
your
all.
agenda?
No.
Okay.
Because I only met him with General Labia. And afterwards, I did indicate to the National Director that she must kindly advise the Minister of Police that he is not allowed to summon me to any meetings. The only minister who's allowed to summon me to a meeting would have to be the Minister of Justice.
So in your meeting with the Minister of Police and Mr. Nkabinde, what was the topic of discussion on the day? Before you told him to never summon you again?
I recall that as a meet and greet He wanted to know what we do at IDEC. And I know it can't only, I know I talk a lot, but it can't have been only me doing the talking. I can't recall what all topics we discussed, and that is why I'm saying if someone else was there and they could refresh my memory, I would know what I, in all likelihood, spoke about. I can't remember them off the top of my head.
I can
Honestly,
accept if you
Council.
don't recall all topics.
Yes.
But I find it difficult to accept that you recall no topic, zero. At least the weather, just been Christmas or Christmas was upcoming, something.
No, I said we discussed IDEC.
Yes,
He wanted to know about IDEC, how we work, how we operate.
that's all you recall of that meeting.
And I recall that is what we talked about. I think we did talk about IDEC's relationship very briefly with the police, and I said we all got along together with the DPCI.
So to try and help us perhaps get a timeline, if memory serves me well, the minister took office around June, July 2024. You recall?
I'm
Just
sure.
after the elections were in 24. So I think he assumed office June, July. When do you think would have been your meet and greet meeting? Using that June, July as his date of assumption of office.
I'm guessing, and so if I'm wrong,
Yes.
please don't hold me to it. Could have been October, November.
October. Do you have your diary with you that perhaps you might cast your
I'd have
eye
to
on
check.
and it help us?
No, I'd have to check in my electronic diary, yes.
Okay.
Can I just ask this
Yes.
meeting where you say he wanted to discuss a criminal matter, was that a matter that you are already seized with, or he wanted to lay a complaint? Is that?
He wanted to, it was nothing to do with IDEC. It wasn't even a matter within IDEC. And I think he was trying to figure out whether this matter, this referral, however he was going to do it, must go to IDEC or to the DPCI. And within probably 10 minutes of the way the matter was introduced, I was able to say, apologies, this doesn't fall within the mandate of IDEC, and that Libya, if you don't mind, you stay, and I'm going to leave, and I had left.
And the meeting obviously would have had to have been after the meet and greet, where the minister asked about IDEC, and you had already told him about how IDEC works and its mandate.
That is correct.
Okay, thank you.
Thank you, Chair. Perhaps this might be an opportune time to consider a short break. I'll have an engagement with Mr. Bodlani.
How long or short it is will depend on the two of you. We'll hear from you. Let's adjourn.
Thank you.